opportunity to provide you with, I guess, my knowledge around work health and safety. This is the first work health and safety webinar for APA for this year. And so we thought we'd start with an intro to work health and safety and really have a look at what are some of the obligations of a business, and also for those that are individuals as senior managers. So without going into too much depth around law as such, I just thought I'd give you some insight, I guess on the surface level of duty of care, and then share with you my experiences dealing with clients for the past 14 years in this space. So we'll get to it. So I see my role as being one that helps businesses deal with the complex and mind-boggling. The thought of having to deal with safety compliance can really push people further away with dealing with work health and safety rather than attracting them to it. It is quite, the law is quite detailed, and like I said, can be quite scary for some people. So my approach is to make the complex and mind-boggling as simple as possible, and this can easily be done. So I wanted to share that with you today. In my experience, where safety fails is where you have an organisation or individuals that treat safety as I guess as a side note. So what I mean by that is safety is seen as a separate business issue and one that will be dealt with when the business has time to get to it. So if that's the approach that you are adopting, that means you're in a reactive state, and essentially you'll never achieve compliance, because health and safety law is about being proactive. So remember, it's not about the injury management side of it, it's about how do we prevent incidents from occurring. So I wrote a blog last year about the safety side hustle. And so, you know, your hustle's your everyday work that you're focusing on, your operational issues, your everyday business, and how safety tends to be the side hustle for many. And like I said, if you don't have time to get to that, it'll be a band-aid effect. So it usually comes into play when something happens at the work site, say there's an incident, and then people are scurrying around trying to deal with first aid or send that person off to the doctors. They might be concerned that, oh, is this going to result in an investigation from WorkSafe? And then you go into that reactive mode. So the whole point of health and safety law is to remove that mindset of it being a side business issue and intertwine it into your everyday business, so that you're doing things to prevent injuries rather than just reacting to injuries. This is a scale of commitment that I put together around, as a business, where their commitment lies in regards to health and safety. And there's a reason that I'm providing this whole intro to you, because this really leads in nicely to duty of care, and I guess helps explain it a lot. So if we start at the bottom of the scale of commitment to health and safety, Sorry,
we're just having trouble seeing your slides. It's just logged out to that to the first screen. I'm just going to try and sorry. Sorry, has it come up to view your screen? Again, I think it logged out for some reason. It's up there at the start. You there?
Yes, I shared the screen.
Okay, it might just take a minute to come up. seemed to be working at the start, but then it's
Okay.
dropped. Yeah, it's still saying, here we go. All right, looks like we're back up and running now. So,
Okay, so you can see the scale.
all good, yes.
Okay, great. Sorry about that. There's always something wrong, isn't there, with computers? Something always happens. Okay, so you should now see on your screen the scale of organisational commitment. So I guess in my experience as a safety consultant over the past 14 years, I can definitely say that I've seen all sorts of commitment coming from different businesses. And I guess I'm happy to say that, 99% of businesses that I've worked with are not in the negligent part of the scale. So that's a good thing. But one of the first things that I do when I work with a business is I really want to get an understanding of where they feel they are in regards to their commitment to health and safety. And surprisingly, people are very open and honest about where they're at. So it's very common for a business to identify themselves between the grudging compliance and compliance range. So I guess this is where we were talking just before about, I guess a reactive approach to health and safety. And I guess it's not on purpose. You don't want to be reacting to these issues. It would be great to have a system set up where you've got policies and procedures in place, your staff are trained, and you're doing everything that you need to do. But I guess one of the biggest barriers to this for a business is not knowing what they need to do with health and safety. So it's very common for a business to say, start out with an audit. Let's get an audit and see what we need to do. Probably not the best place to start. The reason that I say that is because you're going to have someone come in, audit the business on health and safety, and then at the end of that, they're going to give you a long list of all the things that you're not doing. And that can be quite overwhelming. I've had clients where I've done an audit before, and then I hear from them a year later and say, okay, we're finally getting around to that long list of things. We're not sure where to start. So I'm of the approach, it's all about the bite-sized approach. So let's take some small steps to achieve safety, and let's not try and make it bigger than it needs to be. So it's, like I said, it's very common for them to be in the grudging compliance to compliance range of the commitments that scale. I find that once you've educated the senior leadership team around health and safety responsibilities, they become obviously more aware and more willing and committed to do something about health and safety. So I truly believe that imparting knowledge onto the decision makers of a business will encourage further commitment to health and safety. Okay. Like I said before, health and safety is very often treated as a side issue. It's what I call the poor cousin of HR. So it's we really don't want to have to go down that path. It seems too hard to deal with. We don't have the resources internally to deal with it. So maybe let's just ignore it. The problem with ignoring compliance requirements around health and safety is probably tenfold. So there's many different consequences for not meeting your duty of care. And I mentioned that duty of care is being proactive, not reactive. So the consequences are not meeting your duty of care. So it will be seen as a breach of work health and safety law. And there's prosecution and significant fines that are associated with that. But that's just the tip of the iceberg. There's also workers' compensation impact. So your workers' compensation premium will be significantly impacted. And then you've also got common law. So common law is that general duty of care. And what can happen then is the injured worker can then sue a business for, I guess, breaching that general duty of care. There's been an example recently of this. So you may know Lorna Jane, a very high-profile clothing retailer. One of their workers in Brisbane actually is suing Lorna Jane for allegedly for bullying, and she is now seeking just over $500,000 in compensation for the impact that's had on her psychological state. So I guess it's important at this point in time just to make you aware that when it comes to work health and safety law, the term health actually includes psychological health as well as physical health. So when we're looking at what do we need to do around health and safety in our workplace, one of the very first steps that I encourage a business to do is have a discussion with their staff and start identifying what are our operational risks, both physical and psychological. So just as an example of what a psychological risk might be, it might be bullying. That might stem from conflict. It may be work pressure. They may be exposed to traumatic situations. So they're just some examples of what psychological risks are within a workplace. Sometimes it's easier to focus on our physical risks because we can see them. So for example, walking into a warehouse, someone's being hoisted up on the tines of the forklift, we can see that that's an issue. However, with bullying, for example, it might be quite hidden. So it might be happening one-on-one at a time when no one else is around. So that can be quite difficult to identify, especially if the person who's the victim doesn't want to, I guess, deal with that. Okay, so that's the business's commitment to health and safety. There's another level here. So the business has a duty of care as a corporate entity, and then we've got the leadership team. So if you're a decision maker, so the most senior person of the organisation, and it doesn't matter if you're small, medium or large, health and safety law applies across all types of businesses. And so that's probably one of the common questions that I get is, we're a small business, you might only have 1 or 2 staff. Does the law apply to us or is it different for us? The short answer is no. The same duty of care applies to your business as it would to a medium or large size business. So you're expected to do, I guess, have the same systems in place, but to a different degree. It needs to reflect your operational risks. So who is responsible for what the business does and doesn't have in place? It actually comes back to those decision makers, the most senior people of the business. And those most senior people of the business can be held accountable if the business doesn't have the right safety processes in place. And that's pretty scary for some, because what that means is that if there is an injury, for example, and the company's been seen to be in breach of their duty of care under work health and safety law, the attention will then be directed on the senior people. What did you do to ensure that the business had a process in place to prevent injury from occurring? And if that individual, as a senior manager, cannot demonstrate that they had those things in place, they can be held accountable, prosecuted, and again with significant fines, and at worst there's also jail time associated with that. So again, I come back to another scale of commitment from your senior manager perspective. Again, when I talk to my clients about this, especially the decision makers, I'll ask them, where do you feel you fit on the leadership scale in regards to health and safety? And the common response, again, very open and honest people, is we're probably in this reactive approach, but I guess, they feel that they're in the genuine because they do want to do something about it. But in the past, they have been reactive. What that means is that anything below the proactive level of commitment means that senior leaders are not meeting their due diligence obligations under work health and safety. So if we're talking about minimum obligations in relation to individuals holding that due diligence obligation, we need you to be at a minimum proactive commitment. And our ideal is to be progressive. So I guess that's our world class. Anything below genuine is concerning. Okay. So the impact of having a business that is, I guess, grudging compliant or just compliant, and a leadership team that is, I guess, genuine, just going back to that, so genuine or reactive, that has a significant impact on your worker engagement. So you can never sell safety to your team if you're already in the grudging compliance phase or you're reactive. So they're just not going to buy it. It never works when you dump safety on someone else within the organisation to deal with when they don't have the knowledge or the senior support to do something with it. And that's probably one of the biggest failures that I see in health and safety. Someone else has been held accountable, or the safety role has been handed over to the juggler. So, that might be the person who's got many different hats within the business: payroll, HR, operations manager, and so on. Can you do safety as well? What that means is that they're going to be pushing up to get that senior support and also trying to push down to get the worker engagement, but it's not going to happen. So where we have the reactive approach from the business and the leaders, your workers are going to be uninspired, and it's going to be really difficult to get them to follow any instructions in relation to safety. We need our workers to be on board and inspired by what the leaders and the business are doing around health and safety. And the key to doing that, it's very simple. It's so simple it might even sound ridiculous, but I can say in my experience, most workplaces don't do this properly, is having the conversation with your workforce, getting them involved, handing over some decisions to them as well. So you would say, these are all of our issues, our operational risks that we're dealing with in regards to health and safety. We're really not sure how best to tackle that. We would love your input, so let's work on it together. Ideally, that's what safety looks like. It's not policies and procedures that are developed at the top. It's not pushing significant changes around work health and safety onto the workforce without having their input and their input considered throughout that process. Okay, so I'd like to just focus on officer due diligence for a moment. So a very common question is, can I, if I'm a senior person, if I'm a decision maker, so the director of the business, or if I'm the one who's making decisions around the business's financial standings, can I get out of my due diligence obligations? The answer is absolutely not. You can delegate some of your, activities around due diligence to somebody else within the business. So get someone else to help you along the way. However, if there's a gap or if there's a failure there, it'll still come back to you as the officer. So who is an officer? The law actually refers to the Corporations Act to define who is an officer, so who holds that individual accountability for health and safety in the workplace. So if you're a director, there's no buts about it. You are deemed an officer and you have due diligence obligations. If you fail to meet those, there's significant fines and potential jail time associated with that. Who else can be an officer? So the Corporations Act says that if you make decisions for a whole or a substantial part of the business, then you may also be deemed an officer. However, in Australian health and safety law, this has only been tested once. So, I mean, officers are being, as directors, are being prosecuted all the time for health and safety failures. But those other ones where it's quite grey, do you make decisions for a whole or a substantial part of the business? Like I said, it's only been tested once in Australia. When we talk about New Zealand health and safety at work law, which is only implemented April last year, it's based on Australian law. It's only just been implemented, so we haven't had that tested yet in New Zealand, but the same applies. So the test case was around a construction company, and there was a project manager who was looking down the barrel of a prosecution as an officer. In the end, he actually avoided prosecution because the court couldn't prove that he was an officer. Well, they proved that he wasn't an officer based on his reporting requirements and also his ability to make decisions for the business. So basically what it came down to is, as a project manager, he had senior leaders that were above him that he needed to check in with to have decisions made. So he wasn't the ultimate decision maker of the business. So in turn, the court said he wasn't an officer in that particular case and he wasn't prosecuted. However, if that had been the director of the business, definitely they would have been facing due diligence failures. So I've just, seen a note that the slides might be delayed. Again, apologies that we're having these technical difficulties. Okay. So coming back to leaders who owe the due diligence obligations, like I said, you can't afford to be in this range here, but I guess don't stress if you are, because I can say that the majority of the clients that I deal with start out within this phase here. Once they've got the knowledge of what they need to do, they do have plans in place to head for this proactive, and some get a bit excited and even head for this progressive range. I'm just going to take a drink, sorry. Okay. So I mentioned some of the consequences before of not meeting your duty of care. So I've got the consequences for both work health and safety law in Australia and health and safety at work law in New Zealand. However, the consequences are pretty much exactly the same. So for the most serious breaches of health and safety law, so what we call here in Australia a Category 1, so these are incidents of reckless endangerment, so reckless acts. An example of that is, and this incident did happen in Australia, where there were supervisors that were aware that a truck's brakes were not working, and knowing that, they instructed a 19-year-old driver to operate that vehicle. As a result, the brakes failed when he was operating the truck, and he died as a result. So that is an example of reckless acts under work health and safety law, knowingly putting someone in a situation where death or serious injury is likely to occur. So that actually holds carries a maximum, so these are maximums, of a $600,000 fine and a 5-year jail term, or a combination of both. A category 2, which is where most health and safety prosecutions fall into. So that might be that one of your workers has fallen from a height and fractured his or her leg, and as a result, you were seen to breach your duty of care, and the maximum fine that carries is $300,000. A category 3 is up to $100,000. So they're the maximums there. So quite significant fines associated with failure to meet duty of care. Sorry, that's just for the officer. They're the individual fines. That's not the business fines. So that just puts that into perspective for you. I'm not sure if any of you got to have a spare $600,000, but that's a lot for an individual to be facing. So what is due diligence? Luckily, the law defines that for us. We actually have criteria that we need to meet as a senior person who has due diligence obligations. So the law says that an officer must make sure that the organisation has appropriate systems of work. So we're responsible, so I'm saying we as if I'm an officer, we're responsible for what our business does and doesn't have in place in regards to health and safety. So if we haven't consulted with our workforce on the hazards in the workplace, if we haven't recorded incidents and carried out incident investigations, if we haven't set up appropriate safe systems of work for manual handling or to safely operate plants or to handle chemicals, then as an officer, we can be held accountable because the business doesn't have those things in place. As well as ensuring the business has those systems, the senior management also have the responsibility to actively monitor and evaluate how health and safety is managed within the organisation. So it's not a set and forget, it's about what are we actually doing to keep our eye on the systems that we've set up and ensuring that they're actually effective. What's our communication process to and from the workers who are the ones who are exposed to the risk on a daily basis. And if you don't have that documented, if you don't have processes set up for that, if you don't have meeting notes and I guess walk-through inspections and those types of documents that show that you're actively looking and monitoring health and safety, then you're not seen to be doing it. So think about where's the evidence that we can produce to say that we're doing all of these things right. So in summary, the criteria for due diligence is keeping up to date with work health and safety matters. I'm not sure if you've seen that show, Undercover Boss, but that's where, the most senior person of the business is in disguise and actually goes into the business and finds all these things out about where the issues are, why workers are performing the way they are. And in each of those episodes that I've watched, the interesting point for me is there's always been health and safety matters that are identified. So if you're not out there speaking to your team all the time and observing what they're doing, it's really difficult for you to keep up to date with those work health and safety matters. To have a face there is really important. So that then forms part of the next part. Do you understand the work that your workers are doing? Or is it just through other people that you understand what they're doing? Have you actually stood there and observed how they do a task? Have you spoken to them about how they could be doing it better? What are the opportunities to lower the risk for your staff? So it's knowing the risks. How do you record what those operational risks are? So if I was to walk into your workplace today, where is a document that tells me that these 10 hazards are your top risks for your business? Again, if you don't have that, it's really difficult to prove that you're being proactive and in turn meeting your due diligence obligations. You also need to demonstrate that you've allocated appropriate resources to manage health and safety, or is it your safety side hustle and you're just dealing with it when you have an opportunity? So what are you using to help you out with sorting out the best way to manage health and safety in your workplace? Do you have some internal resources that you can use? Are you engaging consultants where it's probably beyond your internal resource expertise? I said earlier that communication is probably one of the biggest reasons that health and safety fails in an organisation. So what are your processes for communicating to and from the workforce, health and safety matters and improvement opportunities? How do you know what your health and safety duties are? So how do you know what you're supposed to do? Have you attended training before? So this session might be part of your due diligence, seeking to understand what you need to do. And there's no defence in I didn't know that I had a duty of care. So the law says that you ought to have known. Okay. So I mentioned before, hopefully the screen, the slides are keeping up with me. So on the screen now is an image of the poor cousin. So I identified health and safety as the poor cousin. You know, we'll only deal with you when we've got time. But we know that, you know, everybody's strapped for time. So if that's our approach to safety, we know we're not going to be compliant. So let's get on the front foot if we're serious about doing something about health and safety. Okay. I mentioned before that sometimes the juggler or your HR people or payroll, someone in this management support level seem to always be handballed the duties of the leadership team to manage health and safety. If this is the situation, it's unlikely that you're going to achieve health and safety success in your workplace. What happens, I mentioned before, is this person is stuck, and I'll say stuck. They've been nominated to manage health and safety. They might have limited knowledge around health and safety. They don't know where to start. And then they're constantly seeking approval from the leadership team to get things done around health and safety. Because the leadership team aren't having the conversation, so this communication down the left side with the workforce, there's no presence, they don't see the urgency and they don't understand the operational risk. So they might be, the leadership team might be in a position where they're turning down recommended actions from their management support team. So I see this management support team as holding the weight for health and safety. They're constantly pushing up. There's a breakdown in communication between the leadership team and the workers. Our workers then become disengaged because they can see that the leadership team aren't committed. So that's very common for me to see that within a business, that approach. And again, I don't think it's on purpose. I think it's just not understanding how important health and safety is when it comes to the duty of care and what needs to be done to get it right. So there's a lack of understanding there, I think. Okay, so this is what it should look like. So ideally, and I know it's easy for me to say that, I know there's a lot of work that sits behind this type of structure. But at the end of the session today, I'm going to give you, 4 ways you can kickstart safety. So you're heading towards this model. So don't start with an audit. Don't delegate health and safety first to your management support team. Start here and, get educated about what you need to do about health and safety. Start talking. So open up these communication lines. So if you're not sure where to start, just get out there and start talking to your people. When I go in and say, do a project, a piece of work with a client, my first port of call is the workforce. So I actually could spend half a day to a day talking to the workers. I watch what they do. I ask them how they do it. I ask them how it could be improved. I ask them if they could design it themselves, what would it look like? So that's the best place to start if you're not sure where to start. Once you've got a really great understanding of what, as a business, you need to be doing, then engage your management support team to help you out. Get them involved in designing what your strategy is going to look like. And that might be, I'm sure you all have a business plan. How about you just put some safety objectives within your business plan rather than having a separate safety plan? Workers will see your presence, their engagement will increase, and then this flow will happen here because it's not being handballed, the weight isn't sitting in your management support team. So hopefully you can see the difference there about what commonly happens with health and safety and what we need to achieve. So what's your vision for health and safety? So I've spoken about due diligence, about duty of care, but what's your actual vision? So we can't fix everything overnight. That's impossible. A lot of businesses try to do that. Well, we've got about 100 different hazards that we need to deal with now. And now that we've spoken to our workforce, what are we going to do? And then it doesn't happen because, or it doesn't happen properly. It's not managed effectively. So I've got this approach, which I call one risk. So for the next 6 months, pick out your biggest risk and put a strategy together on how you can manage that one risk. Okay, so if you're doing nothing at all, don't try and go and address everything. Start with your biggest risk and let's focus on that and do it properly. So engage your workforce. This year we're going to tackle manual handling. How are we going to do that? Okay, so now we've spoken a lot about officers. I just want to, and I have spoken about the business's duty of care, but I'm just going to put a name to the business here. Health and safety law across Australia and New Zealand actually identify the business, so your business, as a PCBU. That's a person conducting a business or undertaking. So your business is known as a PCBU who holds the primary duty of care to your workers down here. So we've got the business who holds a duty of care, the officers as individuals, so the senior managers, workers, so these two here, PCBU, your business, and your senior management, owe a duty of care to the workforce, as well as others who enter the workplace. So what does primary duty of care look like? As a business, what do you need to be doing to meet your primary duty of care? We've already spoken about, as an officer, what do you do for due diligence? It's keeping, it's being aware of all the things that are happening out there. But primary duty of care is about actually implementing a process to protect the health and safety of the people. So we're ensuring the work environment is safe and without risk to health. You know, that things aren't going to fall off racking, fall on our heads and squash us, or that people aren't going to fall from height, or that people aren't at risk of being crushed between a wall and a forklift. So we need to make sure that our work environment is set up as safe as possible. So what's our system look like around that? Do we have safe plant and structures? So if you have any type of equipment that you're using in the workplace, you know, it could be cutting machines, you might have printers, it could be more significant plant such as loaders and forklifts and all sorts of things, what are we doing to ensure that that equipment is safe? Have we done a risk assessment on each of those pieces of equipment to say these are the things that can cause harm and these are the best ways to manage it, for example, by putting a guard on it? Do you have procedures on how to do the task safely? And look, when I say procedures, they don't have to be 10 pages long, because who's going to follow a 10-page procedure? Let's make it as simple as possible. I love the procedures that are the one-pagers that use images to show us what maybe personal protective equipment we need to wear. And then in dot point, give us some instruction about the safest way to do that task if possible. Those procedures then could be laminated and displayed next to the work task where people are actually doing the work. How are we training and instructing our workforce on what those procedures look like? So you obviously get the gist of what is a system and what is primary duty of care. So it's really about, in short, it's what procedures do we have available to make it safe, and how do we inform, instruct, and train our staff in those procedures. And the very last part to that is, what are we doing in the workplace? So the undercover boss style approach. What are we doing to monitor the effectiveness of all the things that we've put in place? So if we've said that if you're going to use a step ladder, you need to follow this procedure, how do we actually make sure our staff are following that? Do we go out and observe? Do we check that the ladders are in a good condition? Are we observing that people are standing on the very top rung of the ladder and leaning right over? If we are, what are we doing to stop that? Are we holding another training, so a refresher training session with them to say, we've noticed that this is happening, this is our procedure, we expect you to follow that procedure and there's consequences if you don't. Because you can't say, well, they just didn't follow it. You need to enforce that like you would any other performance management issue. Sorry, I'm just going to take a drink. So our duty extends to, well, what's reasonable? What's reasonably practicable? If you're a small business, there's no way you're expected to have the systems that a large or, I guess, high-risk business is going to have. That's just not reasonable. Your safety manual might be 4 pages long, and that's absolutely fine, as long as it adequately reflects and represents the risks of your business. So don't feel like after today you then need to go and develop a 200-page folder about all the policies and procedures around all the possible hazards in the workplace. It's focusing on what are our main risks and what are we doing about it. What the law says is that if you have a risk and it's high and you can't afford to manage that risk, then don't do that activity. A big mistake that businesses rely on is the defence of cost. We couldn't afford to put a guard on that machine. We couldn't afford to train our staff in how to use our new trolleys to avoid manual handling risks. Because the law says that if it's too high, the risk is too high, you can't afford it or mitigate the risk in any other way, then do not do that activity. So who are your workers? So this one might be a bit surprising to some. So I mentioned before that you have a duty of care to your workforce. And the term worker, both under New Zealand and Australian health and safety law, includes a whole range of workers. So whether you pay someone or not to do work for your business, they are deemed your worker. So if you had a volunteer coming in for a couple of days or a student on placement, you owe them the same level of duty of care as you would anyone else. All right. So you don't say, well, this is our process for volunteers and this is our process for workers. You treat them the same. It may be that you have casuals over a busy period. They still need to be inducted. You still need to show them what your policies and procedures look like. You still need to monitor and observe their working conditions. So the duty of care doesn't just extend to a direct employee. It could be an on-hire worker, a student on placement, a volunteer, even contractors and subcontractors. If you operate a business and you get a tradie to come in to, say, repair a light, you actually have a duty of care to that person as well. And there's a separate process that needs to be set up to manage the health and safety of contractors coming into your workplace. That one can be quite scary to some people as well. The other nifty thing about health and safety law is because in Australia and New Zealand we've had this whole rejig of what safety law looks like, it's come up to speed with modern day workplaces. So it recognises that, you know, the one business isn't always the only business that's responsible for a worker. You could have a working arrangement where there's a number of PCBs, a number of businesses that are all responsible for the one person. So like I said before, in a busy period, you might then go to a recruitment firm, ask them for a temporary staff member for the next 2 months. In that case, your business is deemed a PCBU, and the on-hire firm, the recruitment firm that you've gained the temporary worker from, you're both deemed the duty holders. And so what the law says is when there's more than one person that's responsible for a worker, you share that duty and you each need to exercise your primary duty of care. So what that means is you can't say to the labour hire firm, oh, so they're your responsibility because you're paying them. It doesn't actually work like that. It means the labour hire firm need to induct and monitor the health and safety of the worker. And it means you also need to do that for the worker when they're at your business. So there's a shared responsibility there. You cannot contract out of your duty of care, even though it's been attempted before in contracts. You cannot do it. You both owe that duty of care. So if that worker were, say you had a labour hire worker for a few weeks and they were injured at your work site, potentially both of you could be prosecuted for not meeting your duty of care if they were able to demonstrate that you in your business did not induct them, they weren't aware of the safe work procedures, you didn't ensure their health and safety. The same goes for PCB number 2, which is a labour hire firm. What did they do to ensure the health and safety? Before they placed the worker, did they come out to your work site and do a risk assessment and ensure it was a safe place to send their worker? So just to give you an idea of case, so how this actually plays out in the court, depending on the severity of the injury, and so we're talking only about work health and safety prosecution, not workers' compensation law or common law here. So, you know, the fines can range anywhere from, you know, $1,000 up to, like I said, the potential, which is for a business, you could be facing up to $3 million as a business or up to $600,000 as an individual senior manager. So there's 2 cases that I've just picked out here, which we can actually send the details of when we send out the survey. But this is more just to give you a bit of insight to what the fines actually look like. So this first one here, the company actually received a $10,000 fine. That was more of a minor injury. This one, I think there was a fracture there, and so they received a $120,000 fine for not meeting their duty of care. So the law says that when there's a shared duty of care, so going back to the labour hire arrangement before, you need to consult, cooperate and coordinate with that other duty holder to make sure that each of you are doing the right things to protect the health and safety of the worker. So I mentioned earlier, I showed you what the fines were for officers as individuals. And here we've got what the potential fines are for a business. So your business could be facing up to $3 million for a Category 1 offence. So remember, they're the reckless ones. For the Category 2, where most of these prosecutions fall, up to 1.5 million. So quite significant for a business. So now that I've given you an introduction to the landscape of duty of care, I mean, you could go on forever and ever and ever about duty of care and get into the details of the regulations. So the regulations get into what you need to do around confined spaces, what you need to do around chemicals, asbestos, on construction sites, within mining and so on. However, like I said, today, the purpose of today was to introduce you to the concept of duty of care and due diligence. So from here, it's about taking those bite-sized chunks approach to health and safety. So are you ready to take the next step? So the 4 steps to kickstart health and safety, and these are my recommended steps to make sure that you're heading towards a sustainable safety system. Obviously, we don't want to set you up with something that's, an approach where you're not going to be able to achieve what you need to achieve. So like I said, the commitment needs to be there. If the commitment's not there, there's no point investing money in audits, in training and so on, because it's just not going to work. So the commitment needs to be there from management. And then get the conversation started. Start talking to your workforce and asking them what they think the risks are. Make notes of what those risks are. It could even just be in an Excel spreadsheet. These are the hazards within our workplace. This is what we're currently doing about it. This is what we need to do about it. I mentioned, don't jump into an audit. You may have already done so, but like I said, that can really push you further away because it can be quite overwhelming. But once you've actually had the opportunity to talk to your staff and you've got a good understanding of what they see to be the risk, that might be the point where you do decide to get an audit. But I think, again, if we're looking at bite-sized approach, let's just focus on what the workforce thinks are the operational risks and start working on those things. So strategize and think smart and practical. So when I say strategize, I mentioned your business plan before. In your business plan, it would be great to see some health and safety objectives for the next 6 months to a year. What are you going to be doing around health and safety, focusing maybe on your 1 or 2 top operational risks? All right, so that might be, for example, manual handling. We're going to review the equipment that we're currently using, or we're not using any equipment and we're relying on our team to lift all the time. So we're going to focus on reducing the amount of lifting that we're doing and look into alternatives for that. So start at the top, have the leaders talk to the staff. Don't jump into an audit, and come up with a bit of a strategy for the next 6 months to a year. Check in and check up. So once you've got those things in place, you've got the ball rolling, verify and validate that those things are happening. Don't just assume that they are. So get out there, have the discussion, observe, make sure that the staff are following the things that you have set up. And if they're not, ask them why. Why aren't you following these? Is it too difficult? Is it impacting on other parts of the business? Let's work on that together. So today I've been talking mainly about primary duty of care as a business and due diligence as the most senior person of the organisation. I hope that's given you some great insight to what you as a business should be focusing on, especially if you don't have any systems in place at the moment or have a very limited system. If you're interested in learning more about health and safety, you're more than welcome to contact me to discuss further. I have a web page. I also post blogs regularly, almost weekly, around all of these types of matters. And I'm also on LinkedIn, so I'd love to connect with you there. But I think we're just going to hand over to see if anyone had any questions before we end the session.
Thanks, Amy. That was really interesting and some very important information there. We do have a couple of questions. The first one is, where do most businesses fail when it comes to duty of care?
Okay, so failure of duty of care, when we looked at before the primary duty of care, so we were looking at, what does the business have to do to set systems up to meet their primary duty of care? And I spoke about making sure we have safe plant and structures, that, we're providing adequate amenities, we've set up procedures on how to do the task safely. So if we go back and analyse health and safety prosecutions across a number of businesses, the two main areas of failure for a business is with a system of work. So, for example, Coles, they just entered into an enforceable undertaking recently. They actually had a procedure set up for how to move roll cages to move their equipment, but they hadn't enforced it. So that's an example of a safe system of work. So they had a procedure on how to do it, and they said that they would have two people, one person moving it and one person to be the spotter to make sure it didn't hit, a customer. But when WorkSafe observed that, that procedure wasn't being followed. So safe system of work, so the procedure is a common failure, and the other common failure is the provision of information, instruction, training and supervision. So most businesses fall down in those two key areas.
Sorry, the second question was, what types of injuries are the most claimed?
Okay, this one's a really interesting one. Manual handling has always been, so that's muscle, manually handling equipment or even people like patients has always been a significant risk to a whole range of businesses across a whole range of industries as well. So that is the most commonly claimed injury. And I think for one serious claim of manual handling, the average cost is around $8,000. I was actually talking to a client a few weeks ago, and most of their work involves manual labour, and they said that they had 32 open claims related to manual handling. So that's pretty scary if you think that one claim could potentially cost you $8,000. So having 32 open claims is pretty scary. The other one that sits just behind manual handling and is significantly on the rise is psychological injury, and that comes from workplace stress, and then that can be broken down even further into a whole heap of other contributing factors, which some I mentioned earlier around bullying or conflict, or it could be even fatigue, so working hours that then lead to stress, and then, a claim for a psychological injury. So those two are probably the two most claimed injuries in Australia.
No worries, thanks very much. That's it for the questions. So if you do have any other questions, feel free to contact Amy directly. Tomorrow you'll receive a follow-up email with a link to the recording of today's webinar and also a link to view the slides. So that's it from us, and on behalf of Amy and APA, thanks for joining us today and have a great afternoon.
Thank you.